Hi, my name is Ricardo Wyngaard, and in this video we're going to talk about volunteers. A lot of organizations are making use of the services of volunteers. In fact, a couple of years ago it was estimated that there are over 1.5 million volunteers operating in South Africa. So there are huge benefits when working with volunteers. However, it's important for the organization to also know that there are risks and responsibilities involved with volunteers. So this video is aimed at looking at some of the legal implications of having volunteers, but also to identify what steps the organization should take in order to minimize its risks when it makes use of the services of volunteers. So we're going to look at the volunteer policy. We're going to look at legislation, and keeping in mind there are a couple of laws that may impact on the volunteer relationship. And then also we're going to look at what should be in the contract that you sign with the volunteer, you should, in my view, sign with a volunteer when you appoint a volunteer for a particular period of time. So stay tuned. So I've been a volunteer at organizations at a board level and also at the level of operations. But I've also been responsible for the management of volunteers, and depending on how you manage that relationship, it can be quite beneficial. But at that point, I did not understand what the legal implications are for volunteers. And you'll find it interesting that there are at least 7 labor laws in South Africa dealing with different aspects of the labor relationship between the employer and the employee. Now, those laws do not define what is meant by a volunteer. So you have to look at key definitions in those laws to determine if somebody is a volunteer under a specific law. Now, some of the laws that are relevant are listed in this resource that I've developed a couple of years ago, and you can have a look at what definitions are contained in those laws. But these specific laws would be relevant to the relationship of a volunteer. Firstly, the Income Tax Act, the Labor Relations Act, Basic Conditions of Employment Act, the Employment Equity Act, Unemployment Insurance Contributions Act, the Protected Disclosures Act, Compensation for Occupational and Diseases Act, Occupational Health and Safety Act. Now, those laws are dealing with the employment relationship, and the definitions in the laws that are important are the definitions for employee, and secondly for remuneration, and also the definition for employer. So you have to look at those definitions to find out if a volunteer would be regarded as an employee under that specific law. And if the volunteer fits within that definition, it will be important for the organization to comply with the obligations in relation to the volunteer, which is for the employer. So it's very important just to be clear that one definition will not define whether or not a volunteer is an employee or not. So it's not that easy to determine if somebody is a volunteer or not. In fact, it's a difficult exercise, and sometimes even the experts may get it wrong. Now, I want to talk about one particular case that went to the Supreme Court of Appeal. In this particular case, a lady called Romi was volunteering her services at an organization called ER24. So basically what she did was she would go with the emergency vehicles to accident scenes, and that was part of a vocational training to become a paramedic. So one day on their way to an accident scene, the vehicle that they travel in were involved in an accident, and she got seriously hurt. Now, the driver of the vehicle was acting in the course and scope of her employment, and it was established that the accident was caused by her negligence. Now, Romi instituted a claim against the company for damages suffered to her, and I think it was about 6 million rands. So the court had to decide if she was a volunteer or an employee. Now, the court had to decide that under the Compensation for Occupational Injuries and Diseases Act. Now, this is an interesting act because it's saying that if a person is an employee, the employee cannot institute damages against the employer for damages suffered while employed at the organization. So the company argued that Romi was actually an employee. Now they argue that even though there was a volunteer contract that was signed between the company and Romi. But the interesting part about this act, it's saying that if a person is indeed an employee, it doesn't matter what the contract is saying, the legal position is what's important. So the company said that they employed Romi under the law, and the agreement accordingly had no effect because she was regarded as an employee and she could not claim against the company for the damages that she suffered. So the company argued that Romi was an employee. She was not a volunteer in terms of the legislation, and because of that she could not institute a claim against the company. Now, they had to deal with the issue of remuneration because this act requires that a person be paid remuneration in order for the person to be regarded as an employee. Now, they didn't pay any stipend to Romi, but the argument was the fact that she could go on these emergency vehicles and that she was exposed to vocational guidance from their staff members in terms of their experience and expertise. They argued that that constituted remuneration in kind, and because of that she is regarded as an employee and she could not institute a claim. So the court had to consider the facts and the court had to consider the legislation. So the court's argument was under this specific law, it required some objectively ascertainable value in order for that to be regarded as remuneration. So the court said that it's not sufficient for the company to argue that the travel on the vehicles was payment in kind, because it wasn't possible for the court to determine a value attached to that. So in that context, the court decided that she did not get remuneration in kind, and that accordingly meant that she was not legally regarded as an employee of the company. She was actually a volunteer. Next, we're going to look at a case under the Labor Relations Act, and even how more difficult it was for the court to decide whether or not a person was an employee or not. So let's talk about another case where the court had tried to distinguish between the volunteer and the employee. And in this case, the matter actually went to the Labor Appeal Court, and it was a case of a person called Nene. He was appointed as a pastor at a church, and at some point the church terminated the relationship between them. Now, Nene argued that he was actually an employee and not only a volunteer. and he took his matter to the CCMA because the church disagreed with his stance. Vienna's argument was that they got paid a stipend. It was about 1,800 a week, and that was his sole income. His argument was he is an employee, not a volunteer. However, he signed a document, 2 documents in fact, and these documents were in essence saying that he is appointed as a volunteer, not as an employee, and he would render his services on a voluntary basis. Now, he relied on the section in the Labor Relations Act that deemed somebody an employee in certain instances. Now, under the Labor Relations Act and the Basic Conditions of Employment Act, a person may be deemed to be an employee if one or more of the factors listed under Section 200A of the Labor Relations Act are present, regardless of the form of the contract. So when Nene went to the CCMA, the Commission for Conciliation, Mediation and Arbitration, the Commissioner considered the matter and decided that in his view, some of those factors are indeed present. He listed about 4 factors, and he concluded that Nene was an employee, not a volunteer, despite the agreement that was signed by Nene. The church took the matter to the Labour Court, and the court agreed with the CCMA Commissioner. The court concluded that Nene was an employee. Now, a church didn't agree with the Labour Court, and the matter was taken on to the Labour Appeal Court. Now, this illustrates why it's so difficult. Now, I must admit I would have agreed with the CCMA and the Labour Appeal Court, but then I read the judgment of the Labour Appeal Court. So the Labour Appeal Court said we have to look at this particular section in the context within which it was legislated. Now, the context was this. In some cases, persons or companies would employ people, but they wanted to avoid the consequences of complying with the labor legislation. So, in all realistic terms, a person would be an employee, but the employer would sign a contract with the employee to say, actually, you're not an employee, you're an independent contractor. And that was to circumvent the provisions of the employment legislation. So that was the context. The idea was that there should be a contract in place, according to the Labour Appeal Court. If there's no contract in place, the intention was not to regulate those circumstances, because the section specifically says, regardless of the form of the contract. If there was no intention to create an employment relationship, the court said, the Labour Appeal Court said the intention was not to regulate that kind of relationship. Now, in this context, there were 2 documents that were signed, and the documents were basically saying that the church and Nene did not have the intention to form an employment agreement or an employment relationship. It was based upon volunteer services. So the court said that did not constitute a valid binding agreement. The intention was not to enter into a contract, a formal binding agreement. Although it was an agreement, the agreement said we do not enter into a formal employment relationship. And according to the court, the Labour Appeal Court, that was important, because the intention was not to create an employment relationship or even a relationship as an independent contractor. So even though the Labour Appeal Court conceded that some of the presumptions that are listed in this section are indeed present in the relationship, that does not automatically mean that the person becomes or is deemed to be an employee. We have to look at, if there is an agreement, what's the content of the agreement. And the court disagreed with the CCMA and the Labour Court, and the Labour Appeal Court concluded that Nene was not an employee or a deemed employee. So there are other laws that are relevant when making use of the services of volunteers. Two I want to mention in particular. The one is the Older Persons Act, and then there's also the Children's Act. And these laws expect of the organization to comply with certain requirements when making use of the services of volunteers. And let's look at some of the sections under the Older Persons Act and the Children's Act. Section 14.1 of the Older Persons Act provides that any person who provides home-based care must ensure that caregivers receive the prescribed training. The training program must be accredited by the South African Qualifications Authority. The Older Persons Act places a duty on any person, including volunteers, who suspects that an older person has been abused or suffers from an abuse, to immediately notify the Director General of the Department of Social Development or a police official of his or her suspicion, and failure to do so would be an offence. The Children's Act provides for the registration of child care facilities. The Act determines the standards that should be adhered to at such facilities, and also who should be excluded from working with children at such facilities. Under Section 10 of the Children's Act provides that any volunteer worker at a partial care facility, drop-in centre or child and youth care centre who on reasonable grounds concludes that a child has been abused in a manner causing physical injury, sexually abused or deliberately neglected, must report that conclusion in the prescribed form to a designated child protection organisation, the Provincial Department of Social Development, or a police official. Section 97.3 of the Children's Act provides that a person unsuitable to work with children is not a fit and proper person to provide or assist in the provision of early childhood development programs. Section 208.4 provides that no person suitable to work with children may be appointed or continue to serve as a member of a management board. So these two laws are very important when you deal with elderly people, or if the organization deals with children. In some cases, organizations may deal with both elderly people and with children. Now, that has got implications for when you recruit volunteers and also when you do the training. It's important for volunteers to understand that there's a legal duty on them to report certain incidences, or even the suspicion, reasonable suspicion as required in terms of the Act. So they need to do that, and the organization must be able to establish that it actually did inform the volunteers and did do the necessary training. It's also important in terms of recruiting suitable persons, because some volunteers may not be suitable for service in the organization, either at an operational level or even as a member of the board of the organization. So it's important that the organization take those factors into account if it operates in these particular fields. A couple of years ago, there was actually an example of a person who committed a crime whilst volunteering his services at an organization in South Africa. The person was found guilty and sentenced, but it's a sad reality that we have to do the checks, security checks, and we must be diligent as organizations in order to protect our beneficiaries. So it's important for every organization to have a volunteer policy and a volunteer agreement in place. when you make use of the services of volunteers. Now the policy must set the tone for that relationship, and it should be a living document. It shouldn't be a document that you leave on the shelf and you never use when volunteers are appointed. In my view, that whenever you appoint a volunteer, you should make time to go through the volunteer policy with every new person. So the volunteer policy should deal with issues of the recruitment of volunteers, how the organization will recruit volunteers and when the organization will do so, issues of training of volunteers and the induction of volunteers. There should be a time period where the organization will do the induction and do the training, and to also inform volunteers of what's expected under law, in dealing with situations of children and the elderly person. Also the evaluation of board members and management and supervision of board members. So in this resource we actually have a sample volunteer policy. It does not have to be a long document, but it's important for the organization to comply with the essence of that volunteer policy and actually sit down with the volunteer when he or she gets appointed to go through the policy. Then the policy should also say that every volunteer will have to sign an agreement with the organization. If it's for a very short term, it might not have to be a long agreement. It could be a one-page document, but it should at least deal with issues of confidentiality and indemnity. So the volunteer agreement is important. As we've seen with the case of the Labour Appeal Court, that document has in essence formed the basis of the court deciding whether or not the person was an employee or a volunteer. So that is very important. Now there are a couple of issues that should be covered in the agreement. That includes the working hours for the volunteer. I was at a meeting a couple of years ago, and somebody asked, but how does it work with volunteers? And a person got up and said, well, a volunteer can come and go as he or she wishes. There's no regulation of time and length. And I just thought, no, I don't agree with that. So the regulation of time should be captured. Also the place where that will happen should be captured in the agreement. Issues of confidentiality. The volunteer may be exposed to confidential information. You need to deal with that. Also you need to deal with which policies of the organization will be applicable in the volunteer relationship. There might be policies like the use of assets, use of computers. All of those have to be clarified in the agreement. Conflicts of interest, that may also be an issue for volunteers and should be covered in the agreement. Another important issue is about intellectual property. Now it's best to clarify that in the agreement so that there's no uncertainty in relation to those aspects. And there are a couple of other issues, also indemnity, that is important. And again, there was a case that we mentioned that went to the Supreme Court of Appeal, and the indemnity clause was a critical factor in that relationship. So indemnity should be included, and also the indemnity should be clear in terms of what's indemnified. So parties should sign the agreement, and both the organization and the volunteer should keep a copy. Another issue that is important is insurance. Is the volunteer expected to take out insurance? So in a nutshell, the issue of volunteers should not be underestimated by the organization. There are too many legal implications for the organization. Having said that, the intention of this video is, as I said earlier, is to help the organization to minimize its risks in that employment relationship, but keeping in mind that it could be hugely beneficial for the organization to have volunteers, and it can improve the organization's ability to render services to its volunteers if it is managed correctly. And I hope this video has been a useful tool for the organization, and I would encourage you also to obtain a copy of our guide, Practical Legal Guide for Volunteers. Check out our website, the link is below.